Although for the Maasai Shukas, there is still debate on if it is truly original to them.
How D is written AS, does it qualify to be trademarks or is it registered separately?
Classification falls under copyright, but it
Hello and welcome to the Sisters in Law podcast. My name is Beverly Mokaya and I'm here with
Aquila Mokaya. In this podcast, we discuss matters law.
From talking about matters family law, property law, tax law, contracts and matters litigation, we've got you covered.
Remember to like, share, subscribe and leave a comment down below.
So today we have a guest. We have a guest. She will introduce herself in a few, but I will just want to introduce the topic that we're going to talk about today, and then we'll introduce her. We want to talk about intellectual property. Intellectual property is
just the property of the mind, that which is created like
out
works of
yes,
the mind.
Yeah,
yes.
Because normally the conventional way of owning property in Kenya is just having land or a house or a car or something like that. But you can own property in shares. That's a way. It's intangible property, and another form of intangible property is works. And nowadays the world and Kenya is full of creatives and a lot of people are creating a lot. So we felt like it's very important for you guys to understand how this works and how the law comes in to protect this. And to help us understand that, we brought you
an
Emma.
Expert. Our very able expert Emma.
Yeah, she's an expert in this. She's been doing this for 5 years, over 5 years actually, yeah. So she will introduce herself and then we can get into it.
All right. Thank you, Beverly. Thank you, Aquila. My name is Juliet Emma. As I have said, I am an advocate. I practice in the intellectual property field. I have had a chance to interact with a couple of things to do with entertainment law. So I hope that I'll be of assistance today.
You definitely will.
Yeah, she's just being humble.
I know you have. You have to be modest.
She's an expert. We'll realize as we go.
Yeah, actually, as you keep watching, you'll realize how much of an expert she is. Yeah. So I think she's in a better position of explaining everything that I was trying to say initially. So I think, Emma, you can just tell us what intellectual property is and what it's about, the different types that we have,
the classes, how they are protected, the length of time, and what.
Okay. Like you rightly mentioned, intellectual property is the property that's created from your intellect. So it's the creations of your mind. And intellectual property law is what protects the creations of your mind. Intellectual property law is quite vast. Intellectual property itself is vast. Anything that you think of that can be formed out of your mind qualifies as intellectual property. So generally, it's divided into two major sections. There is copyright and related rights, and then there are industrial property rights. Copyrights and related rights, sana they are to deal with music, books, software, and then industrial rights, just as the name suggests, sana things that are more tangible or will eventually become more tangible, things that are created in a more technical sense. Yeah. There are also other classes of rights. They could fall under industrial rights, but see sana, like geographical indications. These are rights that protect things that are unique to a particular geographical location. So, for example, if where you grew up, or where you come from, only a particular kind of plant grows there, and it can't grow anywhere else, and then from this plant, we're able to make, say, a beverage, then you can secure a geographical indication protection for that.
So even like medicine, herbal medicine.
Now that's another type. Mostly things that have gotten protection under geographical indications are tea. There's particular type of tea from India. That particular region has gotten a geographical indication protection for their tea, and also champagne, because it that particular grape only grows in Champagne, and that's what makes champagne. You see.
So I know would have just let me cut you shortly. I know would have like a whole episode on the geographical location bit, but who takes it out?
Um, Now it would have to be the region itself, yeah, that will apply for such kind of protection. Yeah. But what Beverly was saying about medicine mostly would fall under traditional knowledge, especially where in your community, especially for African communities, there are things that we know they work. Like our grandmothers knew, if you chew this thing and you had a stomachache, it would stop. That's a traditional knowledge. Usually traditional knowledge is passed down from generation to the next. It's usually to do with how things works, what doesn't work. Yeah. And related to that is traditional cultural expressions. Now, traditional cultural expressions is how we express ourselves as a community. It's how we can be identified culturally. So, some communities have beadwork. They have beads that would signify, that would tell you something about the person, or would tell you if we're wearing this color of beads, it means in our community we're celebrating this manner of thing. That's a cultural expression. It's the way we're expressing ourselves as a culture, or even folk songs that come from a particular community. When you hear folk songs, you'll be told this one was sung for weddings. This ones were sung if it's a funeral. So that's also another type of cultural expression.
Where
So
does where does Masai Shukas?
that's what I was going to ask. The Masai
Because
Shuka
yeah,
and that's a style for Karamojo. They're called Karamajong, Kara something like their hairstyle. That's we are we can teleport. Pot.
Yes, so those would also fall under traditional cultural expressions. Although for the Maasai Shukas, there is still debate on if it is truly original to them. But the point is, they are identifying themselves as such. Hence, we can call it Maasai Shuka.
yeah, literally, right?
Yes, so yeah, that is where they would fall under. Now, usually traditional cultural expressions and traditional knowledge would be protected within the county government of where that community is coming from. So just if there's something that you know from your community and you're curious, check perhaps the county government has a register of what TC is and TKs belong to you, and they are keeping it well. And also, if you are thinking of using someone's traditional knowledge, for example, or traditional cultural expression, for example, a folk song, in say you have a song and you want to incorporate it, before you go ahead and just use it, consider checking from that community, is this registered? Does copyright still remain for this particular song, and can I have permission to use it in my song? So that's to do with the other lesser known rights that less prominent. Now the industrial rights which I had talked about, they're usually quite a number. I think the most common that you may have heard of is patent, trademark, utility model, industrial designs. Now, a patent usually protects something that is new, an innovation that is new, we've never seen it before, or it's an improvement of something that existed earlier. Yeah.
So, for example, the first person to ever invent the mobile phone, he
Yes.
got a patent for that.
Yes, you would get a patent for that. Or improvements on the mobile phone. For example, if we're talking about the first mobile phones, the first ones were really big. Yeah. And then people went figuring out how to reduce them, to reduce the size. We eventually figured out how to make it touch screen, So such improvement.
Ask on the improvement bit. Do you get a different patent from, or is it like the original one is a mother patent and then you come and get like baby patents? Or do you get, if I let's say I invented a new phone, let's say Samsung, yeah? Like, let's say the Nokia ones for Kitambo. And then you come and invent now the tiny Nokia one, the ones that, they're still Nokia, but ni ndogo ya the kubwa. So do you get a different patent, or is it like subject to this the bigger one, the original one?
So that will be a very lengthy discussion. However, many times it depends on the kind of improvement. And a good example for what you're asking, or a good example to answer that, is the motor vehicle, the automatic transmission. Cars kitambo didn't have, like, you had to change gears. And then now there's automatic transmission. You don't have to do 5 gears before, So the patent that the person who came up with automatic transmission got is for the thing that enables automatic transmission. So he won't get a patent for the entire car because the car already exists. But the thing that he has come up with, the improvement, the new thing, is the automatic transmission technology. So that's what is getting the patent. Yeah. And interestingly, you've mentioned baby patents. Now, the bar for getting a patent is usually very high because it has to be new. It has to be something that we haven't seen before, or an improvement on something we've seen before. And then here in Kenya, there's also something called the industrial application. So there has to be a technical application to what you're creating. The transmitter, automatic transmitter, for example, like you have to show how it's gonna have a technical application. And for that reason, usually in Kenya, it's hard to get patents for, say, software, unless it has an industrial application component to it, which we will explain at a later time when we have time. So if you can't get a patent, the solution is to get a utility model. Utility models are what we call baby patents. So they offer you similar protection. However, it's going to be for a shorter period of time. Patents usually last for 20 years, utility models for 10 years. However, the requirements are less stringent. So if you don't fall under patents, you can consider utility models. And now to that, when we're talking about how things look, like physical things, there's also industrial designs. Industrial designs usually protect the designs of things, how things look, aesthetic presentation, and such and such. For example, this particular chair that you're sat on has a very interesting design. I'm sure it's also functional in a way, but industrial designs usually protect the aesthetic presentation of a thing. So if it's absolutely new and we've never seen a chair of this kind, and then you have the idea, you actually sketch it out and you make the chair and it exists, then you can get protection for the same under industrial designs. That explains how you would get many water bottles, many people who sell bottled water, but the bottles don't look exactly the same. Because even the shape of the bottle itself allows you to identify a certain brand and differentiate it from another. So that alone can be protected. Yeah, that alone can be protected. And it's usually protected as an industrial design.
And I think, of course, we're going to ask you what it means for the owner, the person who has this thing protected. But before we get into that, could you talk about trademarks?
Yes. Trademarks is another that is usually classified under industrial property. A trademark, or sometimes a service mark, but generally all of them are called trademarks. It is a logo, a slogan, a sound, a smell, anything signature that your audience or your customers can use to identify you. It's the thing that separates you from other people who are doing the same thing that you're doing. For example, the Sisters-in-Law podcast. That particular name, when I hear it, I know that we're here to talk about the law. Yeah. As opposed to any other podcast out there.
For example, Just Do It or the exactly.
And also, just before you delve deeper into it, the graphics, do they qualify to be trademarks? So like how Dasani is written in itself, like the how D is written AS, does it qualify to be trademarks or is it registered separately?
Okay, so when you register a trademark, you decide whether you want to register what's called a device or a word. So the device will incorporate how it looks. So if you want a very particular font, the way you're saying, the way the D looks, then you will register it exactly as it looks. Trademark will do is make sure people don't use Dasani with the same font that you've used, with the same colors that you've used. So that's an option to protect it. Or you could protect just the word. Um, like the Sisters in Law podcast, yeah. There isn't anything fancy to how it's written. It's ordinary font. So you could protect it as a word mark just as it is. Or you could do both if it's something that you're open to. Yeah.
And I think I would like to, there's a comment I want to make, and you will correct me if I'm right or wrong. For example, it would be important, let's say, for example, if it's Coca Cola, it's the most common thing that we can talk about right now. There's Coca Cola, the name, there's Coca Cola, the design on how it's written, there's Coca Cola, the color. If you say Coca Cola, you imagine the color, it's red, right? So it would be important to protect all these aspects of the mark, for example, the color, the name, the font, and whatever. Because let's say, for example, someone came up with Coca-Cola and then you didn't protect the name Coca-Cola, you only protected the color. So they say Coca-Cola and then their color is, let's say, for example, purple. They would be able to have a loophole around that, right?
So that brings up an interesting question, especially because of the example you've used. And that's to do with well-knownness. There are marks that are so well-known that if you were to come up with another Coca-Cola, we can immediately tell that you are not the real deal because Coca-Cola is well-known.
Yeah.
So there is that aspect. There's also the aspect of here in Kenya. Kenya, as far as trademarks are concerned, is a first use country as opposed to first registration country. So that means if we find that this particular person, even if they didn't trademark that exact color, has been using it for much longer than you, then there's a possibility they'll have a case, a better case than you will, because they've been in the market, they've been calling themselves this, and now people know them as Coca-Cola, and then you came up later and you've changed the color. Us as the consumers, it's very easy for us to confuse and think the red Coca-Cola have now produced a purple one.
Yeah.
And that's the bar for trademark infringement. Is there a possibility of confusion? If there's a likelihood of confusion in the market, then a person has a case. If a person has a case for opposing a trademark's existence for registration. But also, just to mention, when you register a trademark, I have mentioned that you can register the logo or the word or both, or even a color if that's a signature color and you're sure you want to change, say, in the next 10 years, because trademarks last for 10 years. However, there are 45 classes of goods and services that you need to select. So you can't get a trademark for everything under the sun, because unless you're trading in everything under the sun, then you can't get a trademark for everything under the sun, because some words are generic, some words there would be no likelihood of confusion anywhere. So that's one thing. Secondly, words that you choose can't be generic in the sense that they should not describe the thing that you're selling or the thing that you're trading in, but they should be able to distinguish what you're selling in the sense, when I go to a supermarket, for example, I should be able to see that name and identify that product with you, right? But it shouldn't be describing the product that you're actually selling. For example, the name Apple. It would be very difficult to get a trademark for the name Apple and you sell apples. So I go to the supermarket and I find that it's Apple apples. That's the name. It's the name of the company is Apple, and you're selling apples because it's describing the thing that you're selling. However, a technology company can have a trademark for Apple because it's not describing the thing that they're selling. They're not selling apples, they're selling a technological product.
It's interesting. I didn't know that. So, like, you can't call a company Santa Spaghetti. Like, for example,
and
like,
you're selling
there's,
spaghetti.
because the
So
Santa
you can call it
Maria, Santa
Santa.
Lucia, they are spaghetti companies, right?
However, it is the name Santa. Does it really mean spaghetti?
No.
No,
No. So you see, they could get away with calling it
Santa Spaghetti.
However, spaghetti or linguine spaghetti or I don't know.
Like it should not basically describe the.
Okay.
But I've seen some. Oh, okay. So if you're selling maybe water, you can't call it Maggi something.
You can't call it Maggi or water.
Okay,
Water. The brand name is water.
Okay. So the brand name and the product have to be totally different. It should not be describing what you're selling. Okay.
Okay, I think at this rate, we might end up talking about trademarks, and I don't want us to do that because there's a whole separate episode
Episode
on
on
that.
trademarks, yes.
Yeah, so you've talked about trademarks, you've talked about patents, you've talked about copyrights. Where does content creation?
Content creation falls under copyright, but it could also fall under trademark. Assuming you're a content creator and you have a brand name, and that's how people know you. You have a signature tune that you came up with, a jingle, for example. You have what else could one have? A signature color. You have a slogan that people know you by. Then all those could qualify under trademark. So it's possible to fall under more than one. Even patents, if you come up with something that works, that you're solving a problem that existed. For example, you didn't like the way that tripod stands look and you'd like something different and you come up with something that you've not seen before. You could very well have a patent there. Okay. Yeah, so it's possible to fall under more than one.
And have them registered separately. Okay.
Okay, so I think I had asked you a question. When we're done, I think we'll try and give a summary of what she has talked about so that, we are the lay people in this, okay, lawyers, but, she's an expert. So we'll try and see if we've understood for the good of our audience anyway. But I wanted to ask you the question I had asked you earlier. What does this mean for the owner, the person who has registered this thing? Yeah, what does it mean for me if I have registered this trademark or this copyright? Yeah.
Most intellectual property gives you something like a monopoly. So, copyright, for example, is the exclusive right for the person that has been granted that copyright or the owner of that copyright to use that work, either to use it, distribute it, change it, or allow others to deal with it as they please. And that carries for all the others as well. So for patents, they're giving you an exclusive right to that patent for a period of 20 years. If anyone else wants to come up with a similar thing, if it was a phone, someone wants to make a phone that is similar to what you made, then they have to get your permission. The same thing for utility models and industrial designs. So that means if someone does it without your permission, you can enforce your right. You can go to court, you can go to another quasi-judicial body, for example, the Copyright Tribunal, to address that issue. You can go to the Kenya Industrial Property Institute Tribunal to address that issue. So that is, in a nutshell.
If someone uses it without your permission, you can sue them and they'll pay you. If it's in your favor, they will pay you. Okay.
So ideally, we've said that what it means to the owner is that they have exclusive rights to use and distribute whatever right they have. So if I'm the owner of the song and I have copyrighted it, I have the right to distribute it and to use it. And if you have to use it, then you have to seek permission from me.
So I can license it at a fee.
Yes.
Okay.
I would encourage it.
Yeah, so I think that's it for the first part
the
one of this
introduction,
episode. Yeah. There's I give a summary. So there's copyrights, if you're a musician, content creation, a writer, if you have a software, if you've come up with a software what? A software?
A software.
Yeah, a program,
software,
yeah, it can fall under copyrights. Trademarks, just think Coca-Cola, right? Or a company name or something that you want to be, for it to be specifically identified with just you. If you think you're going to go big, you register it as a trademark, even if you don't.
Good practice.
Yeah. But nowadays people are doing it, but I think people have started realizing, so they're doing it. And then patents, if you have something new, the bar is high, like you said, but if you have something new, you can patent it, and then yeah. So I think those are the main ones
I think
that we talked
there's
about.
utility design.
Utility models, those are baby patents. If you don't qualify for a patent, don't lose heart, you can go for a utility model. Yes. If you have something, a unique design that you really like and it's working, you can get an industry
Design, yeah. Anyway, we've come to the end of this first part of this episode. Thank you for watching. I'm sure you've learned a lot. We are learning a lot.
Yeah.
And yeah, we hope that you're learning a lot as well. So thank you for watching. Remember to remember to watch. Remember to subscribe, share, and comment down below. See you in the next episode.
Or shortly, remember to also ask questions so that as we proceed, you can get some sort of clarity.
Yeah. See ya. Bye.